Hello and welcome to Next Steps for Seniors Conversations on Aging. I'm your host, Wendy Jones, and we have a topic that I think is going to be so interesting for everybody. And it's what you need to know about your family's finances. Yes, that is it. Before somebody passes. And you'd be shocked how many people don't have information. And that is why we are extremely blessed to have Rob Kaplow with us today. He is an estate planning attorney with Maddin Hauser. Maddin Hauser here in Southfield, Michigan, which I'm extremely excited to share it with you. How are you, Rob? Good to see you. Thank you for being here.
Wendy, thank you so much for having me. I appreciate being here.
Yes, it's your knowledge is incredible. I've known Rob for a couple of years here, and he's just such a smart man, and there's a lot we can all learn. Did you know, let me start with this, listeners, recent data in the U.S. indicates that 60 to 65% of men die before their wives. Now, I know everyone's like, what? But this happens. It's real. It's a fact. And this is why we're here today, because we need to be prepared now before something happens. So let me ask you this question, Rob, just to start. And as far as bank accounts, because I get this call all the time, people want to know what's the advantage and disadvantage of having my kids' names on a bank account?
Sure. So people are asking that, Wendy, because they've heard that they want to avoid probate. They think that probate is the worst thing in the world, that it's a public record, which it is, but it's not really as complicated as it was years ago. However, it is an extra step, and people do want to avoid that. So people will say, yeah, I'm going to put my kids' names on my bank accounts. There's a right way to do it and a wrong way to do it. The wrong way is actually to make them a joint owner, because if they're a joint owner, then it's a property of theirs. And for example, if one of your children has a gambling problem and there's a creditor, that creditor can go against that bank account. Also, if it's, for example, a brokerage account and you want to sell your stock of Apple stock, you need to get the consent of that joint owner. So that's really a problem. The better way to do it is what's called a TOD or POD. That's basically transfer on death or payable on death. That's a beneficiary designation, sort of like putting a beneficiary on a life insurance policy or an IRA. And that way you still control the account, and it only provides that when you die, it then passes to your children or whoever you named on that account. So that would be the way to do it.
Fascinating. I mean, honestly, never even heard that before.
Mm-hmm.
I'm just being honest, because at the end of the day, people ask me this question all the time. And you know, my answer is go talk to an estate planner.
Right.
I'm not an attorney, right? I mean, these are big decisions. You know, this is everything you've saved for your entire life. And you're just going to put your kid out there thinking it's the right thing to do, and it could turn out to be the absolute wrong thing.
Right. And it can create a lot of problems, again, because if that child does have some creditor problems, that can create a lot of problems. You can also do it with real estate, actually, with your home. And I'm going to throw out a phrase that may sound funny. We do what's called ladybird deeds. And it's basically a deed where you're saying, I continue to control the home, but then when I pass away, it passes to my child. It's called a ladybird deed because there was it doesn't have anything to do with Lady Bird Johnson. But that's why people think that. There was a professor years ago, a law professor, that gave an example of this kind of deed, and he referred to in his example of Lady Bird and the other kids. And so it's become known as a ladybird deed.
Hilarious.
Right. But basically, it's the same kind of thing. It's basically you're naming a beneficiary on that property. And again, that still gives you the right to mortgage the property, to sell it, lease it, whatever you do. You don't have to go to your children and ask them for permission.
Approval. Right. Because that's the last thing they want to do.
Right.
So you have all the control until you pass, and then it's transferred immediately over to the child.
Immediately. All the child would have to do would be to record a death certificate, and then it automatically passes to whoever's named on that deed.
And it's got to be done before they pass. You have
the deed has to be before. Yeah. So that deed needs to be recorded with the county register of deeds.
No, look we're learning stuff every second of every day. This is why you're here, though. People don't know this information.
Right.
And it's scary, especially because things can happen quickly. And all of a sudden you're stuck and you're like, now what do I do?
Well, this is why people really need to know what their assets are, especially, again, you just mentioned that the husband dies first. The widow needs to know, where are my bank accounts? Where's the life insurance? Who's the insurance agent that's covering the homeowner's insurance, who's the attorney, who's the CPA, et cetera. And it's very important to have conversations within the family so that both the husband and wife know all that information.
Well, and you have something I believe called a financial affairs record.
Right. And we'll leave that with you and Wendy. If you can probably make that available for everybody. But that's basically a document that lists all those things. It says who your accountant is, your attorney, your financial planner. It lists what assets you have. And basically that is something that my wife loves to have. And I have to admit, I'm a little bit delinquent in updating it, but I need to do that when I get home today.
I think everyone listening to the program right now is saying the same thing.
Right.
Because it's a reminder.
Right.
And that's why we're here.
Right.
Yeah. So it says real estate, investments, I mean, money owed to us, right? Or
Right.
maybe money loaned. You know, maybe you paid for something and your wife has no idea.
Right.
You know, I think it's fantastic.
Yeah, I've had that situation actually come up recently where a husband died and turns out that he had loaned money to somebody and there really was not much information about it. And when the wife tried to collect it, the person who owed the money said, well, wait a minute, I already paid him back. So it was very complicated.
Oh, I could see that happening in a heartbeat. So let's talk about communication. I mean, this component is huge, but sitting down with your family and actually having a conversation.
Right. And I always recommend to clients that, first of all, every client should have an estate plan. What is an estate plan? Estate plan is a document that provides how you want your assets to pass when you die. So you can do that through a will. And the will says where you want your assets to go. If you have a larger estate or maybe a situation where you might have a child with special needs, maybe you want to create a trust for that to remain in trust for that beneficiary. But it's important that you discuss that within the family. Once you have your estate plan, you should discuss that with your children. You should let them know that you've prepared it. You don't necessarily have to say, I've got $1 million over here, I've got 300,000. You can just tell them, look, I've done an estate plan. It's with Rob Kaplow or whoever. And make sure you have a copy of that available for them. And let them ask questions. They can say, well, why'd you say this? Why'd you give Johnny more than me? No,
No, that never happens.
never happened. The problem in that situation, usually the parent is afraid to have that discussion. And then when the parent dies, then Johnny gets upset, with his brother.
Oh, yeah. And then they don't talk. And then
Exactly.
that's the last thing the parents want, right?
Right.
So have the conversation before you get to that point,
Exactly.
which means right now, because nobody
Right.
knows when that's coming.
Right. And again, I recommend that to clients. I have to admit, very few of them do that.
Yeah. I would say, in fact, I'm going to ask you this question. What percentage of people do you think actually do an estate plan?
Probably very low, maybe 20%.
I was going to say the same number.
Yeah.
Because that's the first question we ask when people call in. We're like, do you have a power of attorney? Who's making the decisions? Because at the end of the day, when someone's incapacitated, you need to have somebody lined up,
Right.
a trusted person.
Right. And in Michigan, we're lucky. We do have a statute called a medical durable power of attorney that can enable somebody to say, if I can't communicate my medical care decisions because I'm in a coma or I'm incompetent, I'm naming somebody who in Michigan is called the patient advocate to make those decisions. And then you can provide in the document what kind of decisions you want that person to make. Like, I never want life support, or I always want life support, even if I'm going to be a vegetable, which most people don't want to do. Most people say, I want life support if there's a reasonable chance of recovery. But again, that needs to be in writing in the document. And then the doctor in the hospital will take that direction from that patient advocate.
Otherwise, the state makes the decision, right?
Well, the family would make a decision, but the doctor doesn't know who's going to be. Let's say there's 3 children. And, child 1 says do this, child 2 says do the opposite. If there's a written document saying this person's the patient advocate, or it might say that all of them are jointly it.
It's just making it more difficult for
Right,
everybody.
right.
Yeah. And I could see that being a problem, especially with 3 children.
Right.
I have 3 in my family. And unfortunately, we do run into this,
Sure.
And when it comes to the parents, they both look to me, okay, you're in charge. You have a company called Next Steps.
Right.
So, but yeah, I see this being a real issue in families. And the last thing, oh my goodness, the absolute last thing any parent would want is to break up a family.
Right.
I mean, think about the love and the growing and all the things that you've done together with your brothers and sisters. And if there's anyone even now that's listening that has some kind of dispute between their brother, sister, or siblings, man, it's not worth it.
No.
Give it up, make the phone call, start with I'm sorry, and make amends, because I can tell you right now, that's what your parents would want.
We just finished a very long litigation process where nephews sued their aunt. The aunt was the trustee of their trust, and there was a lot of money involved. So it was probably worth the suit, but it went on for 10 years before it just got settled.
I mean, that's heartbreaking to
Yeah.
me.
Yeah.
And I don't even want to know who won. Don't tell me, because it doesn't matter.
No.
I mean, honestly, at the end of the day, you can't take it with you.
Right.
You can't take it with you. And God knows he does not want to have, this disparity going on while you're here.
Right.
I am so blessed, Rob. Ladies and gentlemen, we are going to give his phone number and website when we come back. So grab your pen and paper. You'll be right back in just a moment.
This is Next Steps for Seniors with your host, Wendy Jones. Each week, Wendy brings resources and information to help guide you through those next steps with elderly parents and loved ones. If you have questions or topic suggestions, you can call us at 248-651-5010.
Welcome back to Next Steps for Seniors, Conversations on Aging. We are here today with Rob Kaplow, and he is such a wealth of knowledge. Honestly, we all need to hear this information about, getting your families on the same page financially before something happens. And it's shocking. It really is shocking how many people we just don't have this, including, probably myself, to be quite honest. Like we're all kind of lumped into this sum together. But it's so critically important for families, and we are blessed to have you. Rob is an estate planning attorney with Maddin Hauser. So thank you for being here again, Rob. What great information, just great information. I wanted to give his name and his number again so you can jot this down. I think it's important to find the right person. I'm just being honest, because every family is different, every dynamic is different, and you just don't want anybody. This is personal, confidential, really important information. You got to have a trusted advisor, and you're so knowledgeable. I just appreciate your knowledge. I've learned a lot already. All right. His phone number, 248-354-4030. All right. You can reach Rob Kaplow when you call. Just say, hey, I heard this on the radio program or podcast. And it's maddinhauser.com, MADDINHAUSER.com. All right. Thank you, Rob. We're excited. And, how do your services work? Just if people call,
Sure.
What would they?
So generally, we would meet with the client, usually in person, but it could be by phone or by Zoom or Microsoft Teams or whatever they're comfortable with. And we would have that initial meeting and discuss what they need. And at that meeting, I would give them an estimate of what their fee would be. And if they don't want to proceed, there's no charge for that initial meeting.
Which is not, yeah.
No.
People, with attorneys, people get nervous because it's like, well, every time I answer the phone, they're going to charge me. But not with Rob. You get to talk, you get to have the conversation, you get to understand all the value and what the price will be. So
Right.
I love it. That's fantastic. Thank you for doing that. So let's talk a little bit more about, and this is important to me because I just had this happen last week. I had a client that I was talking to on the phone, and she's like, you're not going to believe what happened this past year. And I said, what's that? And she said, my husband died suddenly. My ex-husband died suddenly. And I was like, what? She's like, yeah. And and we have 2 children, right? He didn't have anything set up at all. I mean, like he was only 59, so he was young, but still, she was the beneficiary. She was still, like he didn't recognize that they had gotten a divorce in the paperwork and anything. So she was the beneficiary. So she actually had to go before the court. She said it was basically a year that was a complete disaster, but she wanted to do it for her kids. She's like, they don't have anybody else to fight for them because everything he had was going to go to the children. So she spent the year literally, I don't know what the word is, trying to get control, or what is the word, of helping plan the estate or at least get the funds in the right place.
So most people have heard of the word executor, that when somebody dies, the executor is the person in charge of collecting the assets, paying the last bills and expenses, and then distributing the assets. However, executor is a sexist word because if you're male, you're an executor. If you're female, you're an executrix, Trix.
Oh, never even heard that word.
So in Michigan, we are very politically correct, or we were anyway. And we changed the word years ago to personal representative. So the personal representative is the executor. So if someone wants to say executor, that's fine. But the documents usually say personal representative. That personal representative is the person that has to go, as I said, collect the assets and distribute them. In a divorce situation, it can be a real problem because under the law, beneficiary designations, especially of life insurance, if he had named his wife as the beneficiary, the divorce cancels that. And so if he did not make a new beneficiary designation, then you have to argue with the insurance company who's going to be the beneficiary, et cetera. And I had a situation recently also similar where the divorce judgment provided that the husband was going to maintain a $2 million life insurance policy for his wife. Well, he had one in an irrevocable trust that we had created years earlier that was for the benefit of his wife and kids. But because and the irrevocable trust provides that when the spouse, when they got divorced, that the spouse was no longer beneficiary. So this was not going to provide the $2 million for the wife that she was expecting. So we're in the process actually trying to figure out how to resolve that.
Right. And unfortunately, we all know 50% of the U.S. marriages end in divorce. It's a very common thing to deal with. Very common. As sad as it is sometimes, but it's reality. And with that being the case, you have got to look at your documentation, because if you have an X on your paperwork, you're just causing more problems for everybody.
Right. So they need to check not only the life insurance beneficiary designations, but the IRA, 401k, pension, et cetera, et cetera. And even for people who are divorced, they need to check those beneficiary designations periodically. You may have made a beneficiary designation 10 or 15 years ago, and maybe circumstances have changed. People don't remember to do that.
They don't. And that's why they need someone like you.
Right.
So I appreciate what you bring to the table for sure on that, because it's a challenging time, and emotions high. Everybody's running, trying to figure stuff out, and you need a level-headed man like yourself who's like, okay, I got this.
Right.
All right. So let's talk about the difference between a will and a trust, and the most important thing you should have set up.
So the most important thing would be at least to have a will. And a will is a document that provides how your assets are going to be distributed if you die. If you don't have a will, the state of Michigan provides how your assets pass, which is generally to your spouse and kids. And if you don't have kids, it goes back maybe to your parents. It's very complicated. And that may not be what you want. So if you have a will, that just provides where your assets are going to go. But the will does not avoid probate. Some people may want to avoid probate. Not the worst thing in the world, but it is an extra complication. So if you have in Michigan, what we typically do is called a revocable living trust. And that's a document that says, when I die, the money is used for my benefit, it's used for my spouse. When we both die, passes to our kids, and here's the terms it's going to go to the kids. Maybe they get it at age 25, 30, and 35, and prior to that time, they get whatever they need for their support and maintenance. And by transferring title to the assets to the trust during your lifetime, when you die, the assets are not in your name anymore, they're in the name of the trust. So that avoids probate. And so during your lifetime, that document is sort of invisible. It's not a separate tax reporting entity. Once you die, that trust becomes a tax reporting entity, gets an ID number, and pays income taxes and so forth. But during your lifetime, it's, as I say, invisible, and everything is still reported on your own 1040.
Interesting. So let me ask you this question. When you talked a little bit about the ages, is there a certain amount of time that the funds all need to be distributed by, or can you do it over the course of their lifetime? Because some kids aren't ready for it till they're like 40.
So for larger estates in Michigan, what we use is what's called a dynasty trust. And that dynasty trust, literally, if the world existed this long, could go on for 300 or 400 years. Michigan has done away with a rule called the rule against perpetuities, which I won't go into. But basically, you can have a trust that goes on literally for hundreds of years. So most people don't do that, but you can pick whatever age you want. And I've got clients who have said, I want my kids to get it at age 60. Prior to that time, maybe they get whatever they need, but they don't get the principal or a big chunk of money until age 60.
Because they know they're going to need it then.
Well,
they can handle it.
They can handle that. Right.
I would hope by the age of 60, we've all learned something. Right?
A lot of trust can be just totally discretionary, where it's up to the trustee to determine when to get distribution.
Okay.
You don't even have to have a specific.
Well, and then you have people that just skip one generation and go right to the grandchildren.
Correct. And that's for, again, larger estates to avoid some estate tax. But again, these days we have an estate tax exemption of $15 million and, certainly very, very, very small percentage
Very
of people.
small. Yes. So let me just say this. We've got a couple minutes left in the program. I just want to say that, life is short, right? And a lot of our families that we work with right now are saying, no, I don't want you to spend money on me. I don't want to pay for an assisted living. I don't want to pay for home care because I want to give something to my children. Please, this is for everybody listening. You've worked hard your whole life. You want to have dignity and respect, and please spend the money on yourself. Trust me, your kids are probably like, it's okay, mom and dad. If you don't have money, we want you to spend it on yourself. So only you know your financial situation, but these are big decisions. Please really put some thought, prayer, and expertise into this. Call Maddin Hauser, call Rob. I mean, his knowledge is incredible, and we need good counsel in these situations.
Yeah, I actually just had the same conversation with a client over the weekend where her husband died a few years ago and she wanted to know whether she should redo her kitchen. I said, do it. Go
Of
for it.
course.
Your kids are going to be fine. Go ahead and do it.
Right. Exactly. And if this is something that's on her bucket list that she wants to do, but she doesn't want to spend the money, it's like, what?
Right.
You cannot take it with you. We don't know how long we have. I mean, obviously, don't be crazy with it, but yes, I agree. So in closing, we got about 30 seconds left. What would be the most important takeaway, you think, for our listeners?
I think to speak to your family and also if you're going to try to avoid probate, if you want to do a TOD or a POD designation so that assets will pass to your kids after your death, that's a good thing to do too.
TOD, transfer on death. And what's POD?
Payable on death.
There we go. All right. You're listening to Next Steps for Seniors, Conversations on Aging. Don't forget, Rob Kaplow. You can reach him at 248-354-4030.